A hand goes into a machine at work. In most countries, that moment is the first page of a lawsuit. In New Zealand, it is the last page. You will not sue your employer over that hand. The law simply does not allow it. That door was closed more than 50 years ago, on purpose. And every person living here is part of the deal that closed it. The deal fits in one sentence. New Zealand gave up the right to sue for injury. In return, it got help without anyone having to prove blame. Most days that is a very good trade. The days when it is not are the ones worth understanding. Start with the system it replaced. Before 1974, an injured worker had one route to money: sue somebody, prove they were careless. Two men could lose the same finger in the same week. One of them had a careless boss, so he might win a large sum. The other simply slipped, so he got nothing at all. The lawyers took years. The money arrived late, or never. A royal commission examined this and called it a lottery. Its chairman was a judge named Woodhouse. His report landed in 1967, and it was blunt. Fault, he argued, is a terrible way to decide who eats. Then he proposed something no country had tried: cover everyone, for every injury, all day, every day. At home, at work, on the road, on a rugby field. No blame, no courtroom, no argument about who was careless. The scheme opened in April 1974. It arrived with a price tag, and the price was not money. If the country would pay for every injury, the fights had to stop. So the right to sue for personal injury was taken away. Not narrowed, taken away. That rule is still in force. You will find it in the Accident Compensation Act of 2001. Section 317 closes the court to injuries the scheme covers. One narrow gap stays open. A judge can still award what lawyers call exemplary damages. Those are not compensation for your loss. They are a punishment aimed at outrageous behavior, and they are rarely won. So picture that injured worker again, standing in 2026. The wound itself goes to the scheme, quietly, with no hearing at all, which leaves a strange question hanging. If the injury cannot be argued about, what can be? The answer is money that was never handed over in the first place. Wages, holiday pay, parental leave. KiwiSaver, the retirement savings an employer must pay into. That argument goes to a body called the Employment Relations Authority, and it opens on one condition only: you have to have been an employee. That is how an old bargain reached a religious community on the west coast. Gloriavale is a Christian community at Hoperi, inland from Greymouth. It runs farms and businesses, and it has done for decades. For years its position was straightforward. Members were not workers, they were believers, giving their labor to a shared life. No wages, because there was no employment. The employment court looked at that argument twice and rejected it twice. In 2022, it ruled on 3 young men. In 2023, Chief Judge Christina Inglis ruled on 6 women. Those women had been placed on domestic teams as children. The court found the work started at around 6 years old. None of them had picked it. The role arrived at birth with their gender. They were rewarded, the judgment said, but never in cash. They were rewarded with food, shelter, guidance, and permission to stay. In law, that is payment. Payment makes you an employee. The test the court reached for has a name: Section 6 of the Employment Relations Act. It orders a court to examine the real nature of the relationship, not the label on the paperwork, not what everyone agreed to call it. In New Zealand, you cannot sign your way out of being an employee. You cannot be raised out of it either. In August 2026, 61 former members filed claims with the authority. They asked for unpaid wages and entitlements going back years. The total came to almost $40 million. Their lawyer said many of them carry lifelong injuries from that work. Now look carefully at what the claim actually asks for: pay, holidays, retirement contributions, not the injuries. The injuries are not in there at all. That absence is the point. It is not that unpaid wages matter more than a crushed hand. It is that the crushed hand has nowhere to go. 52 years ago, this country closed that courtroom to everybody, including you. And this is not a story about one unusual community. That same section reaches into ordinary workplaces every year. Delivery drivers, cleaners, people called contractors who look a great deal like staff. When the daily reality says employee, the paperwork loses the argument. New Zealanders tend to describe the accident scheme as generous, and it is. It is also a trade, and every trade has a second side. You will never have to prove your boss was careless. You will also never have your day in court about what happened to you. That was decided in 1974, on behalf of all of us. Most of us only ever heard about one half of that bargain.